Roland Mumford with Mumford.law. I was drafting some written discovery for a case that I have, and I thought, wouldn't it be an interesting video to share with those of you who are pro se parties in your own civil rights lawsuits against police officers, as that happens very often because sometimes attorneys won't take your case, and I come across that all the time. So I thought, why don't I share some of the boilerplate interrogatories that are often in Section 1983 cases, or for that matter, almost any federal lawsuit. So I thought, let's create this video. I'm going to share the screen. And again, this is not an exhaustive list of any possible interrogatory that you would ask in a case. These are just some suggested interrogatories that you can ask for your case. I hope this can be beneficial to some of you. So initially, we often begin with definitions and instructions in any part of interrogatories. Now, an interrogatory is written discovery that you would submit to another party. There's a definition of you because some defense attorneys like to play games. I often put in that an arrest or detention shall be considered the same in the alternative. These discovery requests are intended as continuing requests, requiring the person to supplement their responses as required by Rule 26. No part of an interrogatory should be left unanswered. And these are some other definitions and instructions that I'm going to slowly scroll through that you can see on the screen. With some people, you literally have to define what the word communication is, what is a document, particularly in employment discrimination law with some of these defense lawyers. But anyways, this is primarily about Section 1983. And this is literally how we have to sometimes put the definition for a document in with some of these defense lawyers that want to play games. A document literally means anything tangible or intangible that you can perceive or see through visually inform a memory or mental impression thereof or review of the same. So here's some sample interrogatories that are literally in almost all of my written discovery. Identify each person who participated in responding to these interrogatories, and with respect to each person you identify, list the specific interrogatories for which each person provided responsive information. Number 2, if defendant or any person whom you assert would be considered an agent of defendant has made any statement with respect to the subject matter of this litigation, give the name, address, and telephone number of that person, the date, time, and location of the alleged statements, and give a summary of the substance of the statement. Now, number 1 is about who participated in drafting the responses. Now, here we're suing one police officer or a sheriff's deputy, but the lawyer is going to pretty much help draft these from information from the client. But sometimes they will get information from other people, and you want to know who provided all factual information in these responses. Because if it didn't come from the defendant, you want to know who did it come from, because those are people that may have knowledge of the subject matter in the litigation. Now, number 2, that this would be any person, including the defendant, if they've made a statement with respect to the subject matter of the litigation. Who has made statements about this case that the defendant knows about? Number 3, identify all persons whom you or your attorney or other agent have interviewed about plaintiff's allegations and or claims, or the nature and extent of the injuries suffered by plaintiffs resulting from the same. Please include in your response the date, time, and place of each interview, the substance of the interview, and nature of the location of all recorded or written records of the interview. Now, what we're trying to get here is who has the defendant spoken to. The attorney is just going to object, stating work product, that they don't have to discuss who they've spoken to. But we want to know anybody that the defense has spoken to get statements. Number 4, please identify and describe in detail any communications between you and any officer of the court, including magistrates or judges, concerning plaintiff's detention or arrest. In responding to this interrogatory, please provide the following: the date and time of the communication, and so forth. Now, this is important because a lot of times you may have a matter where if it's a detective or the police officer, are they communicating with a judge or a magistrate after the arrest, in particular to get a post-arrest warrant. But we want to know any communication that a police officer has had with a court. And now it may also be pre-arrest in terms of a search warrant application or an arrest warrant application. We want to know any communication with the court of any kind. And number 5 is our boilerplate interrogatory under Rule 702, the rules of evidence, about anybody that could be an expert, and they have to identify uh, the information from the expert or any information that the expert is given. Number six, identify all witnesses who have provided information in the course of the investigation that was exculpatory in nature and would tend to cast doubt on plaintiff's involvement in the offenses for which he or she was suspected and or arrested for. We're looking for Brady material here. We're looking for any information that the defendant knew about that that person arrested, again, in this situation, my client, or really the plaintiff in any lawsuit against a police officer, we want to know if there was some information that maybe the police officer should have taken into account and paused and compare that against whatever information they were relying upon as a basis for probable cause for the arrest. So we're basically looking for Brady material here, or exculpatory information. That's what exculpatory means. Inculpatory means information that which would tend to prove that the plaintiff or the party uh, may have, or more likely than not, committed the illegal offense. Now, number seven, please describe any admissions or statements that you contend either plaintiff has made regarding the incident, his or her injuries, or any other issue in this case, including in your response, the substance of the alleged admission or statement, the date, location, and circumstances surrounding it, and the person to whom such statements were made. We're looking for admissions or statements that basically my client has made. We want to know what the defense may rely upon in terms of an admission or a statement that a plaintiff or a client has made that they may use against my client in a litigation. Now, these questions, these interrogatories are in every one of my boilerplate discovery that goes out. So this is not anything about one particular client that I have. So as an attorney, I want to know if my client has made some statements that maybe he's not telling me, or that he's forgotten to tell me. I want to know what the defense out there knows about any admissions or statements that my client has made that is germane to the subject matter of this litigation. All right. Now, describe in detail any specific conduct or statement of plaintiff that defendant contends or shows that he or she has not been truthful, or that you contend is otherwise probative of his or her dishonesty. If they have evidence of dishonesty on the part of my client, I want to know about it. And this is what they're asking here. Now, most attorneys are going to object to this question and argue work product, but that objection only pertains to what information the attorney may know that may be truthful or not truthful. If the defendant knows anything that my client has said that's not truthful, the attorney doesn't have the proper basis to make the determination of whether they're going to use that or not. I am asking, what does the defendant know, not what the attorney knows. So now, please identify individuals who have knowledge of any facts, issues, or allegations upon which you rely upon in support of your admissions, denials, and or defenses asserted in your answer, and any individual you believe has knowledge of the facts alleged by the plaintiffs in the complaint. Now, for each such person, please describe the subject matter of the person's knowledge, include the individual's job title, home address, phone number, and state the basis upon which you believe and or contend such individual possesses the information in question, and whether or not you have obtained a written statement from any of the named individuals. Now, here, I put in bold, in answering this interrogatory, it is insufficient to provide counsel's address in lieu of that of the potential witness, as the requirements of Rule 26 can only be satisfied by the production of each individual's address and phone number, not the attorney's address and phone number. Now, what a lot of times these attorneys will do is they'll say, well, you can just communicate with us in terms of any witness that we may know about, or any third party that may have knowledge about any subject matter of the litigation. No, that's not, we're not playing those games. Now, they have to provide the person's name and the contact information. All right. Again, for every person whom you expect to provide testimony, either at the trial of this case, in support of or in defense of any motion, give their name and state the subject matter on which the person is expected to testify. I basically want to know here, who is anybody that could possibly testify, and what's going to be the substance and facts or opinions that they may give. Now, the defense attorney is going to object to this question, and they'll just try to say maybe they're only required to give information about any persons that have knowledge of any subject matter of the case. They're going to say here that I don't have to tell you who I may call as a witness. Well, they're eventually going to have to supplement this response and tell me what it is they're going to say, instead of trying to put that on a exhibit and witness list at the time of pretrial disclosures, which would be a few weeks before the trial. All right, or jury trial, that is. Now, please identify with particularity the factual basis for any and all affirmative defenses and or qualified immunity which you assert to claim any claim made by plaintiffs against defendant. For each such defense or affirmative defense asserted, please state, identify, or describe all facts supporting each such affirmative defense. If you plan on objecting to this interrogatory on the basis that facts are not yet known, plaintiff requests that you supplement your response at the conclusion of discovery. I'm basically going at, I want to know any facts they're going to rely upon that they may assert later in a potential uh, motion to dismiss that they may file after written discovery or in a motion for summary judgment. And I'll probably also add to this interrogatory the basis for probable cause. But that sort of goes to the defense of the qualified immunity, because qualified immunity is all about either they had reasonable suspicion or that there was probable cause for the arrest. If any documents relevant to any aspect of or issues in this lawsuit have been lost, misplaced, or destroyed, please identify fully each such document and describe how it was lost, misplaced, or destroyed. That's pretty self-explanatory. Now here I'm getting into, I want to know all general orders, standing operating procedures, policies, etc. Please identify all general orders, standing operating procedures, policies, procedures, or such other, however captioned, that defendants relied upon in the detention, arrest, use of force, communication, search and seizure, interviews, training, confiscation of personal property, exigent circumstances, leave, defense, chain of custody, evidence management, warrant application, download, digital search of photos, and or investigation of any illegal activity alleged and or suspected to be perpetrated by a plaintiff. What we're getting at here is a lot of these police departments, their policies are sometimes called standing orders, or they'll call them procedures or general orders. They have all kinds of different captions for how they basically call their policies. So that's why that's written that way. So I want to know what policies this defendant, police officer, is relying upon to support their either use of force, arrest, detention, seizure, or such other act in the exercise of their duties under the color of law. So that's what I'm looking for here. And then we're going to go back and compare that response to the actual policies produced by the law enforcement agency and see for any omissions or inconsistencies or therefore are the same. 4, we're always wanting to know about, all right, please provide each instance of any reprimand, discipline, formal complaint filed against or any allegation of dishonesty alleged against defendant, persons identified in defendant's initial disclosures or who may be called to testify at trial in this matter. So I'm looking for any reprimand, discipline, formal complaint, or any allegation of dishonesty, either against the defendant or anybody that was identified in the defendant's initial disclosures. Those are the people who have knowledge of the subject matter that pertains to this lawsuit, or may be called to testify about trial. And obviously, because I want to use that information to show under rules of evidence inconsistent statements in the past and issues of credibility. Here I'm looking for, so number 14 is about please provide each instance of reprimand, discipline, formal complaint filed against or any allegation of dishonesty alleged against defendant, persons identified in defendant's initial disclosures, or whom may be called to testify at trial in this matter. I'm looking for either information about prior dishonesty on the part of the defendant or anybody that they may have as a witness. Here, number 16, please state why you sought an arrest. Some of these interrogatories I'm having to skip over because they are case specific and we don't need to be putting that in a video. Please state why you sought an arrest warrant subsequent to plaintiff's arrest, and please identify what custom, practice, law, regulation, policy, standing order, call, procedure, or such other you relied upon in support thereof. This is one of those unique cases where in Georgia there are certain counties where they arrest somebody and they go get an arrest warrant after the fact, after the arrest, and that is something that I have not seen very often, and other attorneys I talk to don't see very often. Seems to be something that's just kind of unique to certain counties in certain states. Number 17, please state what knowledge you have as to the circumstances surrounding the dismissal of plaintiff's charges and what communications you had with any persons pertaining thereto. In addition, and as part of your response, please identify the person, time, date, place, and manner of such communication. Now, what I'm looking for here is that most of my cases, nearly every case I take, the charges are dismissed or there was a not guilty verdict by a jury. Obviously, you cannot file a civil rights lawsuit under Section 1983 for the most part, unless it's an excessive force claim, because then in excessive force, it's only about whether the use of force was proper or and proportionate under the Graham v. Connor factors. So here, I want to know what knowledge this officer has about this, why the prosecutor dismissed the charges. What communications did the prosecutor have with the police officer? Now, another question that I'll always ask is I will ask about where that police officer is presently employed, if they left the department that they were at the time they arrested my client, and where are they now? And I want to know if they were fired, resigned in lieu of termination, or if they just voluntarily resigned. And I want to know all the circumstances about it. Now, here are some boilerplate document requests, and these are literally boilerplate for all of my cases. I'm just going to scroll through this. All right. We want copies of all documents or communications that the defendant relied upon in responding to the interrogatories. Produce all video or audio recordings. I'm not going to read every single sentence on these requests. I'm just going to slowly scroll through these. We want all documents that were part of the defendant's personnel file. Produce all documents concerning any complaint ever made against the defendant as to their conduct as a law enforcement officer. For each allegation of the complaint that the defendant denies, we want any documents that the defendant relies upon. So produce all documents that may be used as evidence of facts or may lead to the discovery of evidence of facts which support your denial of the allegation in the complaint. Some of these are just going to be too much legalese to really get into. For each affirmative defense that you raise, produce all documents that may be used as evidence of facts or may lead to the discovery of evidence which support your affirmative defense. The affirmative defenses are, again, going to be qualified immunity and a number of other immunities that they state in their answer to the complaint. Produce all documents supporting your contention, if any, that another person may be liable. I want to know here if this defendant thinks that, well, maybe the sheriff's office should be liable, or the county should be liable, or any third persons that should be liable. Maybe there's other police officers or persons that this defendant thinks should be sued. So I want to know about that, because we may have to amend the lawsuit and have those people. I want all communications between this defendant and any officer, agent, or employee of any law enforcement agent or the district attorney's office that relate to the criminal investigation and the plaintiff's involvement in any wrongdoing, the decision to pursue arrest warrants against plaintiff, and prosecution, and this lawsuit. Produce any document or tangible thing you relied upon in your response to support any irrational inference, plausibility, totality of the circumstances, and or probable cause to create any exigent circumstance or any other legal basis to detain plaintiff. And so that's regarding a seizure matter. So if you have a unlawful seizure, that could be a question that you ask, or you could replace that with a produce all records of any database searches that you conducted related to the investigation, arrests, or allegations described in the complaint. So